All right, it's my great pleasure to open this special event for students as part of our final bicentennial celebration, HLS in the community. As you may remember, the celebration began on our very first day of classes, last September. And fittingly on that day, we had several lectures by Harvard Law School faculty on the law school's founding, and then we placed a large boulder in the middle of the campus. And on that boulder is a plaque. And that plaque is in honor of the memory of the enslaved whose labor created the wealth that made the law school's founding possible. And that plaque urges all of us to pursue the highest ideals of law and justice in their name. No less fittingly, we close the bicentennial today on the last day of classes with the theme, HLS in the community. Because it is with the skills you all learn here at Harvard that you can advance the ideals of law and justice in communities. Near Harvard Law School, across the nation, and across the globe. Beginning with your time here as a student here at Harvard Law School, but then actually throughout your careers. And that is why I am so thrilled we are joined here today by Judge Dan Polster. Harvard Law School class of 1976, Judge Polster has dedicated his career to public service. Now you're going to hear today about his career, and you're going to hear about a pretty amazing case he has before him right now. A case which has a lot of potential to do a lot of good in a lot of communities that have been suffering around the country. But Judge Polster's dedication to pursuing the highest ideals of law and justice did not begin with this case, nor will they end with this case. They began, to some extent, as he was a student here at Harvard Law School, very active in the Harvard Defenders Organization. But then throughout his career since then, as a public servant and as a very proud native of Cleveland, where he is currently on the United States District Court or the Northern District of Ohio. My fabulous colleague and tort scholar extraordinaire, John Goldberg, will be engaging Judge Polster in a conversation about his career and about this quite amazing case he has before him right now. What I'd like to ask you to do for me right now is join me in welcoming back to Harvard Law School Judge Dan Polster.
Thank you.
Thanks, Richard, and welcome, Judge, and welcome to you all. The format here is I'm going to ask a few questions just to get the conversation going, and then after I've done my bit, we'll open it up for questions from the audience. So, as you heard, Judge Polster is, in fact, a judge on the Northern District of Ohio in the Federal District Court, where he's been a judge since 1976, so he's coming up on his 20th.
Not quite that.
Oh, sorry, 1998.
98.
Which is a 20th, 76 grad, 1998 judge.
I did a little work before
Yes,
became a judge.
I'm getting to that. Among the achievements he accomplished in his career here at Harvard Law School was meeting his spouse, who is a fellow 76 grad, Deborah Coleman, who's a prominent lawyer now in Cleveland. Before joining the bench, Judge Polster served as a trial attorney in the Antitrust Division of the Department of Justice and was an assistant U.S. attorney in the Northern District of Ohio. He was nominated for his judgeship in 1997 by President Clinton and confirmed in 98. And so I think we're going to learn a lot about a very interesting career. So we'll start with that, and then we'll get to more specific topics like the opioid litigation that's currently before you. So looking back from your current vantage point, anything about your Harvard Law School experience stand out as particularly salient, and if so, why?
All right, let me start out. It's a real honor and a treat and a privilege to be here. And I know many of you are here because of the very good food. This is an infinitely warmer and more friendly place than it was 40-some years ago. And that's all to the good. And I give particularly Justice Kagan a great deal of credit. And then, of course, Dean Minow and now Dean Manning, but for doing things that maybe should have been done a long time ago. And I think you're all getting, I think, a better, a richer education. In fact, I was reminded that my class, the class of '76, actually boycotted the Harvard Law School fund because of, yeah, well, no, because we felt there were inadequate clinical programs when we were here. And obviously, our boycott ended because the school's transformed, and you're all having a much richer experience than I did. But it is a treat to be back, and I'm sort of overwhelmed at how many of you are here, and I hope I don't disappoint too many of you. So the best part of Harvard Law School was obviously my wife. But the second best was Harvard Defenders, or voluntary defenders, and that's where I learned to be a lawyer, and it turned out those were the only clients I would ever get or ever have because I've been in public service for 42 years. But that's where I learned that I thought I liked being in the courtroom. Criminal law was very interesting. You know, in criminal practice, you get all of the ethical issues and challenges you're going to see and working through those. Of course, if you have only one case at a time, you can spend a whole lot of time and effort on that. I remember I won my first case on a legal technicality. This is before electronics. We had something called the Decennial Digest, these massive tomes which literally had all the cases, state and federal, for the last 10 years. And we'd go into the library and we'd lug them back to our Carol, sit down and pour through. And I found some Hawaii case which got my client out on a technicality, and I thought I was the best lawyer in the country. I was walking around saying, this is great. Well, the next 5 clients in a row I had didn't show up for court. So I went from the star of the defenders to the laughing stock. And, you know, I was really pretty crestfallen, but then I realized I didn't have a whole lot to say because these clients were all caught red-handed, and probably the smartest thing for them to do is not show up. So, but the point is I really learned what it was to be a lawyer, and I had an interest in public service when I came here, and I was fortunate enough to get a position with the Department of Justice, and it was interesting. In '76, a lot of people looked at me and said, hey, you really want to go work for the Department of Justice? Because read the history books, we just had 2 attorneys general that went to prison. And I said, well, it's a new page now, and yes, I do want to, and it was the right decision for me.
So relevant to that, during your time at law school, were you already beginning, or at what point did you begin to think government law? That sounds like a good way to go. I
remember one of our professors was Robert Potofsky, and he, I believe, had been on the board and subsequently became the chair of the Federal Trade Commission, and so he taught antitrust law, and it seemed very interesting. And I did think I wanted a government career. You know, there are a lot of different things you can do with a Harvard Law degree, and some things are traditional, some non-traditional. But all of you need to understand it's a huge gift, and one of the real gifts about it is that you never have to be a slave to your job, because you have options that a lot of people won't. And if you find that what you're doing isn't right for you or isn't fulfilling, then darn it, do something else. Don't wake up when you're my age and say you missed things. So some of you will want to go to Wall Street. That's fine. A lot of you won't. Some of you will go to Wall Street and decide, hey, it's not for me. Then do something else. So I came in with the thought of going into government or public service. Although there was a heavy dose of socialization back then, sort of not to do that, I resisted it, and it was right for me.
Right. What were some of the highlights of your government lawyering career?
I had some tough antitrust cases, but I had a number of, I did fraud and corruption cases in the U.S. Attorney's Office. I had some big ones. You know, with corruption, there are no disinterested bystanders, so you try and work up. I didn't get all the way up in one, so that was a disappointment. But you go as high as you can. It's always a real honor when you walk into court and you stand up and say, I represent the United States. I was never in military service, but I have now served 2 branches of our government, and there's no higher honor. And I hope that each of you will commit to do at least one stint of public service. Somewhere in the, God willing, 50 to 60 years, you'll be able to work. You don't have to be like me, do 40 and more years. But we need you. People are often critical of government at various levels, and often that criticism is justified. But remember, everyone in government, that's federal, state, local, was freely and fairly elected or appointed by someone who was. So this isn't Syria or Russia or whatever. Government's us. So we need good people who are willing to run for office or serve. And looking around, I guarantee you, some of you are going to run for office and some of you are going to win. All right? And then you're going to say, hey, my friend's in office, he or she could use some help. You know, you'll have opportunities. And so when you get the opportunity, grab it.
For you, what were the best and worst parts of being a U.S. attorney?
Well, the best part was that if I was in court, I brought a case, it's because I believed that the case was worth prosecuting. That one, I had evidence sufficient to convict beyond a reasonable doubt, and 2, it was worth the government's resources to bring that case, and I made that decision. It wasn't just because some client wanted me to pound someone. So that took a lot of exercise of judgment, and I was, candidly, John, I was a lot better at that at the end than at the beginning. How do you get judgment? You make some mistakes, you learn from them, and do better the next time. Same as a judge.
Happens in teaching, too, it turns out.
Well, it certainly happens as a prosecutor, and it absolutely happens as a judge. So, you know, no one patted me on the back. You know, you have to have a pretty good inner gyroscope and understand that you've got to make tough decisions, but you've got to do them fairly. You have awesome power, and you learn how to exercise it. And sometimes the best things I did as a prosecutor, and certainly the best things I've done as a judge, are the things I haven't done or haven't said. You learn sort of self-control and discipline and humility. So I tried to learn those.
And it's one common path to the judiciary to go through the U.S. attorney. Is that something that was in the back of your mind? It's something you would, obviously you can't plan on becoming a judge since there's so many contingencies, but was that something you were kind of thinking someday?
No, I always get asked that, and I didn't have a plan to be a judge. Right? And you can't, I mean, some people do, and maybe they're really, you know, I certainly didn't.
In this room, possibly.
Well, it's great if you do. It's great if you do, because we need, you know, trust me, it's all the branches of government are important. But if you look around the world and you say, you know, where would be a place I might want to live, I think there are 2 main indicators. One, if there really is a strong, independent judicial branch, and 2, how does that society treat women? And I think the 2 are related. So we're lucky to have this. Our founding fathers were very smart. They put together a heck of a Constitution. I always wonder what the Constitution would be like if we had used the other half of our brain power, country's brain power, which were women. Imagine the Constitution we'd have, but it's still pretty darn good. And this idea of an independent judiciary was very important because, particularly now. So somewhere along the way, I was in court obviously every day. I saw what judges did. I thought I knew what judges did. Of course, I only knew, it's like the iceberg. I saw the tiny tip, what they do in the courtroom, which is really the smallest part. But I thought, well, maybe this is something I can do. There's no higher honor, obviously, than to be a judge. You really are upholding the Constitution every day. So I was a real long shot, a dark horse, so I guess I'm a good example. You know, if you have a goal, go for it. If you don't get it, okay. The failure isn't not succeeding. The failure in anything is not trying. So I went for it. If you ask any federal judge, put any federal judge on a polygraph, he or she will admit that there was a whole heck of a lot of luck in getting the job, and that there were a lot of very good people who were just as good who didn't get it, and no one would say I was the best. If they do, they're not being truthful. So I was fortunate. I did a lot of work in the community. If you do community work, you always get more than you give. One of the things you get is some wonderful friendships. And a few of my friends were able to call a senator's office and speak to the senator rather than 5 staffers below like most of us. So they went to bat for me. And there was a whole lot of luck and timing, so I got it. But you know, that keeps me humble. It also, as you mentioned, John, I was nominated in July 31st, 97, confirmed exactly a year later. I could write a couple of books about that year. Maybe I will, maybe I won't. But it wasn't that I was blocked, so I had to work through that. And it made me a much better judge having to work through that.
Can you say a little bit more about that last point?
Well, I was blocked over the 30 miles because I was from Cleveland and not from Akron. I mean, it seems like ridiculous, but remember Tip O'Neill, who was the Speaker of the House from right here, said all politics is local. Well, all politics is local, and it was a big issue, and so I had to work through it. As you know, you won't read about, you know, blue slips and blocks and holds if you pick up Article 3 of the Constitution. But we have them, and you can't steamroll a senator. You know, you have to work through things and hope that he or she will eventually pull the blue slip out of the pocket and send it in. Right. If no blue slip, no hearing. No hearing, no confirmation, no judgeship. So it took a whole lot of work, and a whole lot of people went to bat for me in the year to convince the senator to take the blue slip out of his pocket and send it in.
Sounds like a case of good karma. So you've been doing this for 20 years now.
Which is hard to believe, but that's the math. Yeah.
What do you know now that you didn't know going in about the job, and what in particular?
That I could write several books about. As I said, I really, again, if any judge is being honest, he or she would say there was far more about the job that we didn't know, and didn't know at all, than what we did know. And that was certainly the case for me. I came in, obviously I knew criminal law pretty well. I knew my way around the courtroom. I didn't know much about civil litigation. I knew zero about employment law, zero about patent law, zero about ERISA. I mean, I knew so little that I remember the first week I got this case, and I said, it was only $3,000. I gave it to my lawyer and said, get rid of this thing. It's not $75,000. Bingo. Great. I got rid of a case. An hour later, my clerk came back and said, Judge? I said, yeah? It's ERISA. What the hell's that, ERISA? I said, ERISA. There's no jurisdictional limit. It's a federal statute. I got to keep this $3,000 case? So I did, and I had to learn about ERISA. Okay, so, but that's the challenge. I mean, you know, if I've always said you need 3 good things to be a judge. You need a brain, you need a heart, and you need something below the belt. And if you come up short, you can come up short up here. Why? I mean, you can sort of borrow that. You read briefs, you ask questions, you read books. No one knows it all. You can supplement what you know. Any good lawyer does it all the time. The other two you got to have. So I read a lot, asked a lot of questions, learned a lot, sort of grew into the job. And I think most judges would say they have grown into their job. It takes a long time to do that. And maybe that's why it's good having a lifetime appointment, because if your health stays decent, you have a long time to grow into your job. And I'm a far, far better judge now than I was in 1998 and 1999.
Okay, well, let's turn to the particular topic of the opioid litigation that's in your courtroom
One that
now.
everyone's asking about. I'm a sort of a public figure. Judges are no, I mean, most judges, if you saw them, you wouldn't even know who they are. I mean, even the Supreme Court justices, unless you were a Supreme Court litigator, they walk down the street, you'd probably be unrecognizable. I'm not unrecognizable anymore.
So, okay, so it's pending litigation, and I know probably that means there's some things you can't talk about.
A lot of them, right.
But that hasn't stopped you from saying some things, and so we'll talk about that.
Right.
First, some nuts and bolts. If you can tell us, just to remind the audience in a very few sentences, who's suing whom for what, and what are these lawsuits? How did they get to you?
All right, okay. There are, I get a printout each week. Our clerk's office gives me a printout of all the cases in my multi-district litigation. I started with about 100 when I got these the first week of December. We're now, what, 4 or 5 months down? It's now up to close to 700 as of yesterday. Almost all of them are brought by cities and counties and states who have sued the major drug manufacturers, the manufacturers of prescription opioids, and the distributors of those drugs for, under a whole lot of theories and statutes, but a quick summary would be that the claims against the manufacturers are that they sold and marketed these pills aggressively as being safe and effective for treating long-term pain, when in fact they are highly addictive. And the principal claim against the distributors is that, you know, these are controlled substances, Schedule 2 and 3, and they did not do an effective job of ensuring that the pills went just to where they should have gone, and that millions and millions and millions of pills went walking and got diverted and led to a whole lot of addiction and ultimately death. About 30 years ago, Congress passed a statute, the MultiDistrict Litigation statute, that permits, if there are a whole lot of cases, similar cases filed in federal district courts around the country, for them to be consolidated in front of one judge for pretrial management, motions, discovery, maybe settlement. And there is a committee of 7 judges, a standing committee, obviously the members rotate, of 7 judges that hear petitions to create multi-district litigations, and they decide, are we going to create one, yes or no? And they decide based on whether they think it'll be more efficient and effective for the litigants and the parties to create one or not. If they decide to create one, next question is, all right, which judge are we going to ask to do it? So this one, it clearly made sense to create a multi-district litigation because of the size, the complexity. Many of the cases, they were basically making the same allegations. And I got a call, and the panel asked me to do it. Now, why did they ask me? Some days I wonder that. And some days I wonder why I know why I said yes, but there are days when I say, well, is that the right thing to do? But I think that they were going to pick a judge from Ohio, West Virginia, somewhere in there, which is sort of the epicenter of the opioid crisis epidemic. Obviously, I'm in Ohio. It's a little easier for the hundreds of lawyers to get in and out of Cleveland than Wheeling or Charleston, West Virginia. Second, I don't think they were going to give this case to a judge who had not handled at least one complex multi-district litigation before. They weren't going to give this to a rookie. That made sense. There's not one you know, it should be your first one, so I had had a couple before. So they called me. I could have said no. It wasn't the Army. I mean, if I had said no, they would have found someone else. But, you know, that's not how I was raised. You know, if you're asked to do something very important, even if it's hard and you don't know if you're going to succeed, I was raised to say yes. I mean, that's so, and particularly something that is causing so much pain and suffering and heartache, you know, I wasn't going to say no. So that's how it came to me.
Right. So when you have a hearing in an MDL like this, you've got...
I could charge admission and make a lot of money, but can't charge admission.
Hundreds of lawyers or scores of lawyers in the rooms. There's not enough seats.
Right.
Right.
Like this, we have an overflow room. We did.
So at a recent hearing, you made some interesting statements, and I'm going to read a few excerpts of them in case members of the audience aren't, just to give them a flavor of what the kind of things you were saying to the lawyers in the courtroom. So this is you speaking, quote, "This is not a traditional MDL. What's happening in our country with the opioid crisis is present and ongoing. I did a little math. Since we're losing more than 50,000 of our citizens every year, about 150 Americans are going to die today, just today, while we're meeting. And in my humble opinion, everyone shares some of the responsibility, and no one has done enough to abate it. That includes the manufacturers and distributors, the pharmacies, the doctors, the federal government and state government, local governments, hospitals, third-party payers, and individuals. The federal court is probably the least likely branch of government to try and tackle this, but candidly, the other branches of government, federal and state, have punted. So it's here. My objective is to do something meaningful to abate this crisis and to do it in 2018. And we have here, we've got all the lawyers. I can get the parties and I can involve the states. So we'll have everyone who is in a position to do it. And with all these smart people here and their clients, I'm confident we can do something to dramatically reduce the number of opioids that are being disseminated, manufactured, and distributed." End of quote.
I did say that.
I'm glad I didn't make that up. So
I made it up.
Yeah. So this is a remarkable statement, and in many ways. One way, which I'll just focus on and that will lead to a question, is you're clearly casting yourself in the role of a national problem solver. From your perch as a judge, you are going to work with the parties and lawyers to at least try to make a dent in this crisis. I don't think anyone is going to challenge you on the goals you are seeking to achieve. They are immensely admirable. But what about the means through which the goals are achieved, right? You're a judge, and this is civil litigation, and you learn in the first year of law school, at least from some professors, that civil litigation is about resolving disputes between the litigants, but this seems like something quite different than that. This seems like a policy, a judge making policy. So what's the vision here as to that, under which this is your job, as opposed to all of our jobs or our representatives' jobs?
Well, it's a very fair question, and I didn't consult with anyone when I said what I said. And I think some people were pretty shocked and wondered what the hell is he doing or saying or trying to do. I was just speaking like a person, not as judge. And, we're ordinary people with extraordinary jobs. We put our pants on one leg at a time. We get angry, we get upset. We're no different. And I wish that when I put the robe on, it gave me magical powers, particularly with a case like this, because I could sure as hell use those magical powers, like be Superman or Wonder Woman, whatever. I don't have magical powers. I was just saying that, the typical torts case, like I learned here, something bad's happened in the past. The plaintiff thinks the defendant's done something wrong to cause it. The defendant says, no, I didn't cause it. And the lawsuit is about, all right, did the defendant do something wrong? And if so, how much should the defendant pay? Well, what we have is something that's going on, right now. And, we have a litigating track going on right now because I got two tracks. I got a settlement track, I got a litigating track because lawyers are able to do what good lawyers do, pound each other. And so we got that. But at the end of the day, what I felt was that everyone can agree on two things. No one wanted or intended to have millions of people get addicted to prescription pills, and no one wanted or intended to have 50 or 60,000 Americans die each year. So, and this is not an act of nature like a tsunami or a hurricane, all right? We created it. Men and women created it, so it's on us to do something about it. And if you sit around, as you all know, you sit around waiting for divine inspiration for some perfect, all-embracing, all-arching solution, that's an excuse for doing nothing. The way you tackle something hard is you say, all right, it's real hard. I don't know how to solve it all, but I think I can take these first steps. And so you do those steps. And then Professor Goldberg comes along and says, all right, you're here. Well, we can go here. And Professor Lazarus says, all right, you're there, we go there. And that's how you get it done. So people are saying, I said I was going to solve this. First of all, it's not me. All I was trying to do and am trying to do is get everyone together to see, all right, what can we do to turn the curve down instead of up, 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 up. So people are working very hard. Everyone thinks that this is all I have, but I have this on top of all my other cases. And I was not given any additional resources. So what I'm using 3 very smart and talented special masters. The parties are paying for them because there's no budget that I have. And they've been meeting with the lawyers like every 2 weeks. And then they all come in and meet with me about once a month to try and come up with some systemic things, again, to change the trajectory. So maybe this isn't what courts should do, and we can have, I respect people who think that, darn it, this is not what a court should do. This should be handled by our legislative and executive branch. But this was given to me. I didn't ask for it. The courts didn't ask for it. We're reactive. I mean, we don't hustle or market, hustle for business or market ourselves. It comes. The lawsuits were filed. So what are we going to do with them? And, this one cried out for at least some effort to come together. Now, one of the, if you read over the last 50, 60 years, people have turned to the courts, particularly federal courts, to tackle some very difficult social problems. And maybe that's good, maybe that's bad, but that's the reality. That's what's happened. So, and federal courts haven't, said, no, it's too hard, I don't know what to do. We do it. And maybe the fact that we're not elected, we've got to be very sensitive about it, but the fact we're not elected maybe gives us some moral authority. So, and we are problem solvers. Lawyers are problem solvers. That's why you look at any nonprofit in the country, you're going to see a lot of lawyers on the board because people, they come to lawyers because we learn a sort of a strategic way of thinking. We anticipate problems. That's not a reason not to do something, but it's a reason to do it maybe a little more cautiously. That's how we're trained. That's so judges are, I look at myself as a problem solver. I mean, it used to be you had a, problem with someone, you challenged him or her to a duel. Well, we've happily moved forward. Although I'm in an open carry state and one may question whether we're not going in reverse, but that's for another day to talk about. But the point is, you come to court, it's a way to resolve a problem. So that's how I look at my job.
So you said you don't have a cape and you don't have a golden lasso or any of those superpowers, but you have a robe.
I should say the one other advantage I have is I can I can invite people to join in. One of the complexities, John, of these cases is that the multi-district court can only consolidate federal cases. There are significant cases brought in state court by attorneys general. There are about 12 that have been filed, and there's a multi-state group of AGs who have been conducting a civil investigation with their law enforcement powers over the last year. It's clear that if there is any resolution, it's got to be a global one, and the states are instrumental. So I've invited their help and their participation. And, you know, what I've learned, you know, you try and order someone to do something, either they say, hey, you have no authority, or even if you do, it's, you know, they're not happy that they were dragged in. You ask someone for help, most people will say, yeah, you want my help, I'll try. So they've offered to participate, making it very clear, excuse me, that I have no jurisdiction over them or their cases, and that's fine. So that's one power that a federal judge has.
What are some of the other tools that you think you can use? Obviously, as you say, it's not going to be a solution by fiat. It's going to have to be a negotiated, cooperative effort to do something about this horrible problem. What can you do as a judge to foster those sorts of developments?
Well, try and do what I think good lawyers do, or what I've tried to do when mediating cases in the past. Turn something from a fight to be won or lost into a problem to be solved, because that's when people use all their brain power. You know, if you're in fight or flight mode, half of your brain shuts off. You got to figure out, I'm going to fight or I'm going to get the heck out of here. So if it's a problem to be solved, then you use all of your brains and your creativity. So I'm trying to be a catalyst. The good ideas come from others, not from me. I may have a couple, but most of them come from the lawyers and the parties, and I can be a facilitator, keep people moving forward. But at the end of the day, it's, you know, any resolution is voluntary. I can't compel that. And again, we have a litigating track, and I've set one case. I should have mentioned, the only case or cases I can try, if they have to be tried, are the ones that are venued in the Northern District of Ohio. So I've set the first case for March of 2019. It's one brought by the City of Cleveland and Cuyahoga County, which is Greater Cleveland.
So one more question, then we'll open it up to the audience. If things go well, from your perspective, realistically, what do you imagine, what would you like to see happen in the next year or 2 years?
Well,
success.
Success. As I said, success would be, in my view, some significant steps that are done voluntarily to turn that curve down, to reduce the amount of overprescription, pills that are going to people and they're getting them addicted, and then dramatically reduce or start reducing the number of pills that are being diverted, that are going to the wrong people, and then helping resources for all the people who become addicted. And if they don't get help, they are turning to street drugs, heroin largely. And in my part of the country, excuse me, the heroin is often laced with fentanyl or carfentanil, and that's where the overdoses and deaths are coming. Okay. So, again, you have a complex problem. It's been at least 20 years in the making. You don't solve it overnight. But you start doing some things to, again, change the trajectory. So that's what I'm hoping to do. But, you know, I don't control this.
Great. So now I'd love to open things up for the audience to ask questions. I think, well, these microphones that are in the tables, I think they'll work, so you can use the microphones in front of you. If not, we have a handheld mic, but welcome questions for the judge. Oh, come on.
Yeah, fire away. Any question is fair. If I, can't answer it or can't answer it fully, I'll say that.
Let me see if this, okay, it works. Thank you so much for coming and speaking with us.
Welcome.
So because the opioid epidemic is very much in the national limelight, I think you've gained some notice for encouraging the parties to settle.
Well, I'm encouraging them to talk about some steps that can be taken to change what's happening. I mean, there's still litigation, and I've set my trial. It's not a bluff. I blocked out several weeks next March, so you may come and watch.
So I'm curious to hear, though, how you think about the balance in making those decisions between private settlement and mediation and very public-facing deliberation for the purpose of people who are watching discovery, for example, or arguments outside of the court.
Well, this is, there's a legitimate debate as to whether we should have more trials and whether it's good to have these out-of-court settlements. And brilliant law professors can write about that and opine about it. Trials are important, but the problem with a trial, it's not like TV, where everything is wrapped up in an hour and you go to the next case. It takes years. And, I have a great trial which just goes to the Court of Appeals, and maybe I made a mistake, and maybe you got to do it over again. So it's important to have that vehicle available, excuse me, and have lawyers who know how to try cases and judges who know how to try cases. But if we had to resolve every dispute by trial, you'd have to wait 20 years for your trial. I mean, we don't have the judges in courtrooms to resolve all our disputes by trials, so we've got to, if I can, again, turn it from a fight to be won or lost into a problem to be solved, you never get everything you want, but if you can get a decent amount and you can move on, think of forget the money, the time and emotional toll that's being saved. So I'm trying to apply some of the things I've learned from mediating cases over the last 20 years to this one, but whether it'll work or not remains to be seen.
Yes. All right, can you press your microphone down?
Thank you. I have at least been told that there is a bit of a bias for Harvard Law students to go to the big cities after graduation. That perhaps there's some notion that sophisticated law is done in New York and Chicago and LA, and that Cleveland may not be the first destination. Can you speak not only from your own experience in the public sector, but from what you've observed of your wife, who was a very successful private sector attorney, has been for many years, what might be the advantages for law students to look in other places?
Good question. I remember, Andrea, I came here to Harvard College in the fall of '69, almost a half century ago, right after the Cuyahoga River caught on fire. And my friends from Boston, New York, they'd never seen anyone from Cleveland. They couldn't imagine why anyone would be from there or want to be from there. And anyway, it's a great place to raise a family. And
Not to be a baseball fan, though.
What? Yeah, good point. What I would say this, the hardest thing for me in navigating adulthood was not being a federal prosecutor or a federal judge. It was balancing 2 careers and 3 kids. And anyone who says that's easy, I don't know where they've been or what they've been doing. It's hard. That, quite frankly, I always wanted to be in the public sector, but I was the one who could be home almost every night, and I had very little traveling, and I had more control over my work than my wife did. And yeah, we could have afforded to hire someone to raise our kids, but that isn't why I wanted to be a father. I didn't want to wake up and suddenly have these teenagers I didn't know. It's too late to know them then, that's for sure. So in a place like Cleveland, obviously the cost of living is far less than here, New York, LA, whatever. I don't have long commutes. I bicycle to work. It's 10 miles, about an hour each way. or it's a half-hour drive or half-hour surface rail. So it was possible in Cleveland, and I don't know how we would have done it in Boston or New York or LA, candidly. So I got 3 wonderful kids. Now they're grown-ups. Now one's a parent, and one will be a parent soon, God willing, and I know them. And so that is a real advantage to living and practicing in places that you wouldn't consider glamour spots. Also, you can do, the other advantage is you can probably make a difference in a smaller place more readily than in New York. I mean, there are 8 million people. I'm not saying you can't make a difference in a place like New York, but it's harder. I mean, that's professionally and in the community. So, again, I'm not knocking anyone who wants to go to New York or DC or LA. I mean, I got friends who do it, and it's great. But don't think that, you know, if you got a Harvard Law degree, there are only certain places you should live and certain things you should do. That would be one of the biggest mistakes you could make, all right? So decide what's best for you, what you want to do professionally. If you want to raise a family, you got to put that first, okay? And it's not for everyone. If you don't want to raise a family, that's fine. But if you do, that's going to be the most important thing you'll do in your life. And you want to make sure that you can balance your professional obligations, your spouse's professional obligations with raising those kids, because they'll depend on you.
Yes?
Judge Polster, you and I have carried on a debate over the years.
And I want to say I am so in awe of Professor Judge Kratz Lee, who was teaching when I was here as a student and is still doing it. And I, you know, so you got a huge round of applause for that.
Just to mention the debate, it has to do with whether a judge who is a problem solver or a mediator and is unsuccessful should go on and can be fair to the parties in trying the case. And we disagree really about whether that's a good idea or not. But I'll just ask the question here. These folks that you're working so hard with and who have this trial queued up, if they asked you to disqualify because of things you've already said, or either at these hearings or I suppose even here today, what guidance would
To myself, well, if I get a motion to recuse myself, I'll have to address it. That's happened before, actually. Early on, I had worked very hard to try and settle a case. It was unsuccessful, and so we were starting the trial, and the week before, defendant filed a motion to recuse me based on something I've said. Well, I wrote a long response to the Court of Appeals. Court of Appeals denied the motion to recuse. I tried the case. I think it was fair. Ironically, the party that thought I'd be unfair won the case. So, but there actually was one time, Professor, when something that someone had said or done during the mediation had, I was so upset about it that I did recuse myself from the case, and it went to another judge, because I felt that it might impact, you know, it was still going to be a jury trial, but I was concerned that it might impact how I would conduct the trial. But generally, you know, if the case settles, fine. If it doesn't settle, that's okay too. You always learn something by trying to settle a case, and then if you do have to try it, well, no one looks back and says, gee, we didn't have to do this. We had some other options. So I think I can be fair whether or not a case settles or not. And I think having the trial judge be the mediator, again, only if the parties want me to. I've never imposed myself, and I don't think a judge should ever impose himself or herself. I always tell the parties, if you want to try and mediate the case, you got 4 ways to do it. You can hire someone. There are lots of good people in every city that do it. Most courts have an ADR adjunct to the court. You can use the court ADR system. You can use the magistrate judge, or you can use me. And I don't care which of the 4, and you both have to agree. And if they both say, Judge, we'd like you to do it, then I say, okay. But I don't impose myself. I think that's, then that's coercive.
Other questions? Sorry. Oh, sorry. Yeah.
Yeah, it's just popping in from the overflow room, actually, for this question.
Welcome.
I can't help comparing this litigation to Colombia, the country of Colombia's dealing with internally displaced persons, and how those courts brought in government, NGOs, lots of different parties to try to resolve the conflict. And I was wondering if you ever look at, or if that's ever in the back of your mind, how international courts may have turned to different kind of solutions, or asking, like South African courts to, for the parties to engage, or for the government to work on a process as you deal with this litigation.
That's an interesting parallel. I hadn't really thought about it. See, one of the other complexities and difference about my case is, because I wouldn't say it's one case, it's 600-700 cases. Typically in these mass tort cases, the plaintiffs are just disparate individuals around the country who don't know each other, have nothing in common other than they believe they were all harmed by the same product in the same way. Here, the plaintiffs are not individuals. They're government officials. They're politicians. They're governors, attorneys general, mayors, county executives, politicians, big egos, big agendas. So I already have all these government entities as the clients, as the plaintiffs. So it adds a whole, they are public cases because they're brought not by individuals, they're brought by government entities to try and recoup taxpayer money. And in fact, that's one of the significant legal issues the defendants have raised, whether cities, counties are even allowed to bring such cases, but they're looking to recoup taxpayer dollars that have been spent on police, EMS, coroners, health insurance, whatever, and expenses that are going to be paid in the future to try and rehabilitate people.
Maybe time for one more question. Who would like the honors? Sorry, yes.
So the other comparison I often hear is to the tobacco litigation. I was just wondering, there's a large settlement there, but there's still hundreds of thousands of people who die each year from smoking. So I was wondering if there's any lessons you can draw from that settlement as you move forward.
Well, it's good, and it's interesting. A lot of people have drawn comparisons. I wasn't involved in the tobacco litigation, but one of the things that it's been explained to me that one of the reasons there are so many individual cities and counties who have brought lawsuits is the fact that the tobacco money was all given to states and it stayed there. It wasn't distributed. And also that most of the money did not go toward reducing smoking. Many states use it as like a big kiddie bank to subsidize all sorts of other things. I'm not saying it was stolen or graft or corruption. It was just done for roads or schools, whatever, other things that government does. But the money didn't go toward combating and reducing smoking. So, those are, but in terms of whether the legal issues are similar or whatever, I'll let other commentators talk about that.
Great. Well, I just want to, by way of conclusion, I just want to reiterate what Professor Lazarus said at the outset, which is having Judge Polster here as a, if you will, living demonstration of HLS in the community as a lifelong public servant and an esteemed graduate of this university and this law school. We're just thrilled and delighted that you took the time to join us, and I think I speak for everyone when I say we admire so much your concern and your effort to make the world a better place through your position, which is exactly what HLS in the community is all about. So please join me in thanking Judge Polster.